Good morning, everybody, and welcome to my presentation. Happy April. So my name is Raluca Soica. I'm a wills and estates lawyer, and today's topic is intestacy. Does it mean that if you have no will, you have no problem? I want to go over what that means and over what an administration of an estate without a will in Ontario means. Okay, so this is how it starts. It's usually an overwhelming time for the loved ones that are left behind. They're dealing with emotions and of losing a loved one, and that's never easy to handle. And at the same time, they have a long list of duties that they have to do and figure out how to do on their own, because either they found a will and they've been appointed as executor, or they can't find a will anywhere and they have no idea what to do. Then they go to the bank and the bank says, sorry, we can't give you access to any of these assets. Just go and talk to a lawyer. So that's where I come in. Okay, so let's talk about the first steps of what happens when somebody passes away. So the first thing is to figure out funeral arrangements. Sometimes the deceased has pre-arranged their funeral and has prepaid for this, and hopefully the loved ones can find the paperwork for that and can find where the funeral home is. If not, they will have to make arrangements on their own and pay for this on their own, which is not always easy because it can be quite a bill. Then they try to locate the will, and usually that's among the deceased papers, but it could be in more conspicuous places, like for example a safety deposit box that nobody knows exists, or at a lawyer's office that maybe they just find this random business card lying around, or maybe they don't know what lawyer has their will and they need help figuring that out. But what happens if there is no will? If there is no will, then there's more confusion because nobody knows who's supposed to be in charge. The will appoints an executor, and that's the person who spearheads things and is the person who would go to a lawyer to help them figure things out. But if they go to the bank to try to get access to the accounts, to the deceased accounts, and the bank says, go see a lawyer, who goes to see a lawyer? Everybody. So it's confusing. And then the question, of course, always comes, well, who gets the money then? There's no direction anywhere. It's a lot of confusion. So these are the advantages of having a will. So like I said, it gives a direction. It appoints the estate trustees. It kind of spearheads the entire operation. It selects beneficiaries. So it can exclude certain beneficiaries if the beneficiary was estranged from the deceased and the family. It sometimes includes funeral instructions and body donation clauses, organ donation clauses. Some people want to have parts of their body donated, others don't. So you can include that in the will. You can appoint guardians for minor children. That doesn't happen if there is no will. You can plan for gifts to beneficiaries in case they have marital problems. So what happens to a gift to a beneficiary who is married and then ends up separating or divorcing a short while later, or even 2 years later? What happens then? You can plan for that in the will. You can limit your executor compensation. So the rule of thumb is that the courts award about 5% of the value of an estate for compensation. Now, that's quite a large amount given the crazy increase in real estate market in the GTA. 5% of that can amount to $50,000, $100,000. Is an executor's job, worth that much? Well, you can limit that in a will. And you can create all kinds of different special trusts, like for example, for disabled beneficiaries. So this is how intestacy happens. So that is when an estate or a portion of an estate passes according to intestacy law and not according to the will. Well, number one, there is no will or no valid will. Number two, the will is lost. That's happened before. Nobody can find it, and unfortunately it is what it is. There are no named beneficiaries. So yeah, a will can if it's not done properly, it could possibly not appoint any beneficiaries, and then too bad that you have a will. They will pass on intestacy. No living beneficiaries. Everybody passed away, or undisposed share of estate. So that means that a will can partially address some of the assets in the estate, but it doesn't address everything. And then part of it passes to intestacy. Okay, so on an intestacy, somebody needs to step forward as a trustee, but there's a lot of things that can halt the estate at this point, which wouldn't happen if you had a will. So it can halt the person from being appointed. Mm-hmm. So there's certain rules. Certain people need to renounce their appointment. There's a certain order of appointment that a person can apply. So not just anybody can step forward. There's a certain order of priority, and all those people in priority or in the same line have to renounce and consent. And what if somebody doesn't? Then what? It can halt the administration. And then the division of assets, it's according to the law and not according to somebody's preferences. So this is the order of priority for those of you wondering, for estate trustees. So somebody passes away, who is the boss now? So the first person that's entitled to apply is the surviving spouse, and there has to be a married spouse, or somebody with whom the deceased lived in a conjugal relationship. If there is no spouse, or the spouse doesn't want to act and is willing to renounce, then the children one child or more children can apply, but the rest of them have to approve and renounce. Furthermore, then there's grandchildren, great-grandchildren, and just others down the bloodline. And if there is no bloodline, so a person passes away without a spouse, without children, and no one further down the bloodline, then it's the parents. If no parents, then it's the brothers and sisters. If there are no brothers and sisters, then grandparents, and then next of kin. So that's the order of priority of applying for to be an estate trustee. It doesn't mean that the court will approve your application. There are a lot of things that you need to submit so to present yourself to the court in the best possible light. So here are some of the requirements to apply. So like I said, all of those of the people in the order of priority, it's not automatic appointment. So they must be an Ontario resident. You cannot apply for a certificate of appointment without a will if you don't reside in Ontario. As unfortunate as that is, with parents passing away and kids living in the States, that's very unfortunate. They have to choose someone from Ontario. They must be appointed by court. That is a requirement. And they need the consent of the majority beneficiaries. So that's what I was saying earlier, that somebody can bring this to a standstill. So it's not just that the person ahead in line and in the same line as you have to consent, the beneficiaries have to consent as well. And you need a renunciation of every person in priority. So remember how I said it's the spouse first, then the children. So the spouse has to renounce. If the spouse doesn't renounce, let's say it's a blended family, second marriage, the wife doesn't want to act, but she doesn't want to renounce, that's a little difficult. A dispute like this can bring things to a standstill. And like I said, a court doesn't have to just appoint a person just because they're next in line in priority. This isn't the throne of Britain. You have to put yourself in a good light when you apply. And if they believe that somebody else is more appropriate, then they will go ahead and appoint that person. So now that we talked about who can apply and who can, let's say that somebody was appointed and the court approved them and all beneficiaries consented and people who had to renounce, and they live in Ontario. And anyway, we passed all those hurdles. Congratulations. Okay, now what? Who gets the money? Believe it or not, I've had executors call me and say, oh, I get to choose now. I get to choose how the estate is distributed. I only wanted these 3 people. And meanwhile, I find out there's like 5 other people that are entitled in line, and one of them died and one of them is disabled. And and one of them doesn't get along with the family, and I say, no, I'm sorry, you cannot choose how this money gets divided. Unfortunately, only the deceased could have done that through a will, and he didn't. So now you have to go by intestacy law. So this is how intestacy law works. So the person dies, and what happens to the money? Well, the first 350,000 goes to the spouse who is married, not a separate, and they have to not have been separated or divorced. This is a recent addition to the Succession Law Reform Act. And after that, so if there's more than 350,000, then if there is no kids, everything else goes to the spouse. If there is one child, the remainder after 350,000 gets divided in half between the spouse and the child. And if there's more than two children, a third goes to the spouse on top of the 350, and then the 2/3 that are remainder gets divided equally between all the children. That's unfortunate in cases of where, blended families, where the person has been in a second marriage, and maybe children don't get along with the spouse, and etc. But then there's complications. What if there's no spouse? What if I have an estate right now where there is no spouse, no children, no parents? So if there is no spouse, it goes to the children. If there is no spouse, no children, it goes to the parents. But what if then there's no parents? And then it goes to the siblings. And if no siblings, there's nieces and nephews. And then what if somebody predeceases? Well, it depends. Did they leave children behind? Then if they do, then it goes to the child's estate. So it's not that simple. Okay, next please. And let's not forget about applying for a bond. This is a very important part, an intestacy, in applying for certificate of appointment without a will. The court, it's not just a simple application, you put some forms together. No, you have to explain to the court why you think the estate has enough money to pay its debts, which doesn't happen in the case of an estate with a will. So if you don't explain that, then you have to put forward double the value of the estate, or who has that. So if the deceased had a house, who has that kind of money to put forward double the value of that? Or you can get a bond, you can purchase a bond with the insurance company, but you have to arrange for that. It costs money, time, and it's one of the stickiest parts. You have to put together an affidavit to explain all of the debts, how you paid them, that you're taking care of everything. It's quite a liability. So that's what you would do if you want to dispense with a bond. There's also some other exceptions if the spouse is the sole beneficiary, if it's a small estate, so under 150,000, and if the applicant is a trust company. So as you can see, administering an estate without a will is an intensive process. Every estate is different. Every estate has a different set of family members and family dynamics that contribute to or hinder the estate administration, and you have to go by a set of rules that is not set by the deceased or by the family. It's unfortunately set by the government, and the government doesn't care if a certain beneficiary doesn't get along with the family or doesn't deserve anything because they haven't been contributing to the family for the past however many years or been distant. That doesn't matter. There is no control there over the process. You have to go with the rules and apply according to the process that's established, and this can be frustrating for some who want to be executors or for beneficiaries. And the refusal of one, like I explained earlier, can stall everything and can lead to litigation, which is expensive, takes time. And on top of it, being an executor is high liability because you put your own personal assets in line when you make decisions for the estate. So you, as an estate trustee, you have to make the absolute right decision and the decision that is in the best interests of the beneficiaries. and you can't pick and choose, and you have to follow the rules, the intestate rules as they are. Okay, so I thought this would be an interesting presentation to just because it's not common knowledge of what happens when somebody passes away without a will. So generally this is what happens, and thank you for attending.